In June of last year, ICE began arresting children in Long Island, New York, picking them up off the street in front of their homes, taking them into custody, and shipping them across the country to distant detention facilities without any notice to their parents or their immigration attorneys. They made these arrests based on local law enforcement officers and agencies telling ICE that the kids were gang affiliated, but it turned out that in the vast majority of the cases, there wasn't evidence to back this up.
Now felt like a particularly important time to me to get involved in a pro bono manner, and particularly an immigration case. For me, this is very personal. My father was a refugee during World War II, and when he arrived in England as a refugee from Nazi persecution, he was put in an internment camp in the Isle of Man. This case was an opportunity to do something significant to improve the treatment of immigrants today, and it was particularly important because these are all teenagers who were stripped away from their family environments, from living with parents and siblings. And it was so contrary to our fundamental notions of due process. These children were taken away with no hearing whatsoever, no opportunity to prove that the allegations were unfounded.
These were all kids who were picked up by ICE, targeted by their local police, by the Suffolk County Police Department, for things like the kind of shoes they were wearing, the kind of soccer jersey they were wearing, and who they were hanging out with.
F.E. was picked up by a school officer for loitering, and they found the number 503 written on a piece of paper in his notebook. They said that that was a gang sign, and they, 2 days later, arrested him, put him in a highly secure jail-like setting in Virginia, and then shipped him across the country, almost 3,000 miles away from his family, to another facility in California. On Monday, November 20th, just 3 days before Thanksgiving, the federal judge who was presiding over our case issued a preliminary injunction order. He certified a nationwide class and issued a preliminary injunction that all of the children who were currently in custody should be entitled to a hearing before an immigration judge or other neutral officer within 9 days.
The hope that that brought to people was really amazing. Talking to kids who we'd been talking to for months who were in custody and been asking, how are we ever going to get out? They finally had a light at the end of the tunnel.
Ultimately, we ended up having 30 out of 32 children released from custody.
I've been at the ACLU for 15 years, and I've worked with many firms over the years, and I've had great experiences with lots of them, but this experience with the Cooley team has been the very best experience that I've had.
I've had the good fortune of winning a lot of major victories over my career, but the first time I ever cried after a decision was after seeing a picture of our first named plaintiff, F.E., hugging his mother and little brother immediately after the immigration judge ordered him released from custody.